case is now being live streamed. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning. My name is Justice Henry, and our panel today includes Justice Sachs and Justice Singh. It's the July 8th, 2021 sitting of the Appeals Court. We are today on Zoom during the pandemic. We have 6 cases on today. The first case is Commonwealth versus Deathridge, case number 2020-P-0724. We will hear from the defendant first. On the Zoom platform, everything is as if we are in a courtroom other than being on Zoom. So we'd ask everybody to keep on their game face. And if we have any technical difficulties, we will bring everybody back and we might pause the live stream, but hopefully things will run smoothly this morning. You might notice occasionally that the judges are looking off to the side. That's because we have the case materials typically on another screen or device, and we need to refer over to them. Rest assured, we are paying attention to you. We just are also looking at our notes. And with that, each side has 15 minutes. There's no rebuttal. Attorney Tenen, we might start your argument.
Thank you, Your Honor. Good morning, everybody. May it please the court. Eric Tenen on behalf of the defendant, Craig Deathridge. In this case, Your Honors, I submit that trial counsel was ineffective because he made decisions with incomplete information. It is not tactical to decide on a strategy when you don't have all the options in front of you. And here, if counsel had spoken to an expert on alcoholic blackouts, he would have seen that there was a strategy that would have been better and different than what was used. But he didn't. And so he relied on a strategy absent this complete information.
So, Mr. Tenen,
yes, Your Honor.
On the performance prong, you have to show that counsel's failure to investigate getting an expert on alcoholic blackouts of victims, which was the case here, constituted serious incompetency, inefficiency, or inattention, falling measurably below that which might be expected from an ordinary fallible lawyer. So I understand that in retrospect, once somebody discovered that there was an expert who might testify to this sort of thing, it might seem desirable to have had that in the case. But is there any other case where that you can point to where an expert has testified on this issue as to a rape victim and consent? How was counsel supposed to know? How was trial counsel supposed to know that such an expert existed and should have been investigated?
Sure, Your Honor. A lot of parts to that question, so I'll try and answer all of them. First of all, in terms of are there cases? So, appellate cases, at least in Massachusetts, there's no case that directly says this is or this is not a certain kind of evidence. There are cases that refer to it, to refer to this kind of evidence, meaning this kind of evidence has been testified about in courts. And I cite some of those.
As to defendants, usually. Candelario, Walker, Frank.
Actually, those are the ones the Commonwealth cites. And in those cases, well, the issues are about whether the expert could have talked about alcohol as mitigating premeditation. But yes, in those cases, some of those experts also talked about the idea of memory and alcohol. But also some of the cases I cite too, Sama, Lash, I'm not pronouncing these right, I doubt, Cruz. Again, these are cases where the issue was testified to, meaning there's an expert explaining to the jury the idea of what ingestion of an amount of alcohol can do to memory, what a blackout is, etc. So this is an expertise that's obviously available. This isn't some sort of new expertise, and the affidavit I submitted from the doctor shows this isn't something new that we've just discovered after trial. It was around that it existed.
Yeah, this expert had never testified before. Is that correct?
That's not correct. I can tell you anecdotally, I actually used this expert myself in a trial I did.
Well, let me put it this way. Is there anything in the record indicating that he testified?
No, there wasn't. We never even had a hearing to play out his qualifications, but
But he didn't put that in his affidavit. I've testified to this X number of times, both for the prosecution and the defense.
Correct.
Or whatever.
No, that wasn't in there, but this kind of evidence is known. This is not some sort of new science. It existed at the time of this trial, and it had been used in cases, at least some reported cases. Now, again, the reported cases are ones in which a defendant is found guilty. There are other, cases that aren't on appeal, where this kind of evidence can be used too. So I think it's not. Sorry.
Well, I'm looking at your brief, page 36, note 4, where you cite Blaish, Sama, and Cruz.
Yes.
And you say numerous cases cite the testimony of experts with respect to alcohol-related issues. That doesn't seem to me to be specifically on alcohol blackouts having such a selective effect on memory as you suggest might have occurred here.
I write it broadly because when you read those cases and you read what the experts testified to, it wasn't just the idea of a blackout. It wasn't just memory loss. They testified to a lot of different things a lot of different ways.
But did they testify to this sort of selective memory loss? I'm forgetting the exact term that you used for the alcohol blackout that kind of phased in and out.
Again, I guess the best I can say is I encourage you to read those cases so you can see a description of what was testified to. It was because it wasn't only what I was saying. That's why I used that sort of term, alcohol-related issues. But the issues I'm talking about here were certainly encompassed in the testimony as I read those cases of the experts in those cases.
So you think it? Sorry, go ahead.
No, if you want to finish the line, go ahead.
Go ahead. I'm set.
Well, considering the testimony of BG and the defendant side by side, is there anything besides the issue of consent that the defendant says she did not remember?
Well, there's two parts to that. One is I don't know if it's two parts, but there are things that she remembered differently. And so I use my words carefully, and I'll explain why that's important. So one of the things, if you read the affidavit on blackouts, one of the things it explains is that what happens is you don't form a memory. And so if you don't form a memory, it's never there. And so if you later try and let me think back what happened, there's nothing to retrieve. Why that's important is because her closest statements in time to when this happened were to the police officers and that was in the record, that was in the testimony at trial. What she told the police officers she remembered and didn't remember was very different than what she said happened at trial. So it is, she somehow seemed to remember more at trial than she did in the days, weeks or months, whatever it was after this happened. So it's not that she didn't remember, it's that she remembered something differently. But if she had never formed a memory, if she actually was experiencing blackout and had never formed a memory, what she testified to at trial could not have been an actual memory. And so the affidavit talks about sometimes what happens is we don't form a memory, but when we go back and think about things, we are influenced by things around us. And so it's possible that what she said at trial happened was not a true memory, but just her being influenced by just the scope of what she thought happened. So that I think is a big discrepancy, a big difference in how she in how she described what happened at trial towards what may have happened had she been blacking out.
So the Commonwealth, though, argues that that the trial court judge was correct in observing that any testimony she had blacked out would be inconsistent with a defense that the victim, was capable of giving consent to the defendant. What do you say to that?
So I think if you're referencing when the trial court said that, basically, I think, and you can correct me if I'm wrong, Your Honor, what you're referencing is the trial court's decision where she says, this could not have been a blackout because she remembered. She could talk about this happening.
No, I think the trial court is saying if she was so drunk, she was blacked out, she was too drunk to give consent.
Oh,
and that there was a ton of evidence that the defendant knew that because he was with her when she was drinking. I think there might have been some evidence that she was smaller than he was and he knew how drunk he was. and that they put her to bed because she was drunker than everybody else, and that everyone kept checking on her so she wouldn't asphyxiate.
I understand. Thank you, Your Honor. So in response to that, one of the things we have to understand about blackouts is that they can happen at different levels of intoxication, and they vary for different people. This is one of the things the experts would have explained. And so, we use the word drunk, and that means something different to everybody. So to say she was a certain level of drunk, which means, if she was blacked out, she was a certain level of drunk that would have looked a certain way, I think is inconsistent with what we understand about blackouts. And so someone can black out, meaning they're not forming memories. That's all that means, is they're not forming memories, but they can act in a way that is that appears totally normal to others. They don't have to be so intoxicated that they're at that point slurring their words, falling over, that kind of thing. They don't have to be. Sometimes they are. Sometimes those go hand in hand, and sometimes they don't. And so someone can do things that to other people appear like they are functioning perfectly normally, but to themselves, they're just not remembering doing those things. So the real question is, as we instruct juries in these kinds of cases, is it's not just was the victim incapable of consent, but also could the defendant reasonably have known that? And if the defendant is saying, well, these are my interactions with this person, and my interactions with these persons led me to believe that this person was fine at that moment and consenting, then you have this thing that only can be explained by, or might be explained by, the idea that, well, if the alleged victim was not forming a memory and doing these things, she wouldn't remember saying these things, even though the defendant was seeing and perceiving these things. So I don't think the fact that she may have been blacked out, meaning not forming a memory, tells you anything about her level of intoxication at that moment.
Right, but when you look then at the affidavit that's in the record from this expert, where does he say that he's reviewed the facts of the trial and it was consistent with the victim being in an alcoholic blackout? Or
doesn't.
you want to put it not forming memories?
Sure. He doesn't, and he doesn't need to. So this kind of evidence, or the form in which this evidence that I suggested could have been admitted, comes in all the time without someone giving an opinion about what is going on in the case. That is, an expert gives general legal principles to an idea that jurors don't commonly know about, and then the jurors take those principles to the facts of the case and decide, okay, I know what this expert told me about this thing. Does that match what I know? And so he could have been called to testify, not to form any opinion about whether this person was or wasn't blacked out. I think that would be very hard for him to do without talking to the person, and I don't know that would have been capable.
Oh, but he does. You agree? He does not say that the description is consistent with an alcoholic blackout.
I agree, and I also agree that if he had been called to testify at a trial, he wouldn't have said it there either. That this is expertise of a general nature, which we allow often and in many kinds of cases. Sorry.
But when we're looking at whether the defendant was deprived of a substantial ground of defense, and we don't even know from this expert whether the phenomenon that he's describing was consistent with the facts of this case, how can we say that the ground of defense was substantial?
The way you as the reviewing court, or a reviewing court, can see is the way I sort of piece it together in my brief, which is to say, these are the facts we have at trial. This is the things that we know were said. So this happened, this happened, this happened. Here's the affidavit saying these are the kinds of things that lead to, or are consistent with, however you want to put it, alcoholic blackouts. And you can see that the things he's describing are the things that are testified to. And so I laid it on my brief. These are the 3 or 4 things that she said that are consistent with his affidavit when he describes a blackout happens in this way. That's what would happen at trial. Not that the expert would say, I've listened to the testimony, or I reviewed it and I have this opinion. Again, this is how a lot of expert testimony comes in normally, where an expert doesn't draw an opinion about what is testified to at trial. They just lay out the general principles of that area of expertise for the jury to then connect.
I, for one, don't mean to suggest that it would be inadmissible simply
Yes.
because he didn't apply his principles to the facts of this case. But I'm asking if he couldn't say whether whether the principles were applicable here, how substantial is the defense? I mean, I can see if he'd been if he testified, the counsel in closing Commonwealth in closing argument would have said, well, you've got this expert and these principles are all well and good, but he can't even say whether the symptoms or the facts here are consistent with this fragmentary alcohol blackout theory. So you can just put that out of your minds, jury.
I take a little issue with that because, again, the affidavit was submitted or made to be submitted in the form that it would have come in at trial, that I suggested would have come in at trial. That is, this would have been an expert to testify to the general principles. At that point, then it's up to the lawyers, the defense lawyer, if you will, to argue to the jury.
Sure, but we still have to make a judgment about how substantial the defense would have been in the form that it was presented in the affidavit.
Okay, so, and that's where I do that in my brief. So I think if you read in the different sections, I say these are all the places, these are all the things that that BG testified to happened, and this is how they line up with the things that the expert wrote in his affidavit about how an alcoholic blackout takes place. That's what defense counsel would have and should have done, is take the testimony that we know exists about what happened, and then you line it up with what the expert said. So I guess I can just encourage you to reread my brief and where I list them out in a way I think matches it up.
So counsel, I had one more question, which is,
Yes, Your Honor.
are you challenging the decision, the order not severing the trials, or are you just saying in your third argument, I mean, your third argument is phrased as the failure to sever meant that the Commonwealth used acquitted conduct evidence. And I'm just trying to understand, are you
Sure.
in fact appealing the decision not to sever?
I think the best way to understand that argument is, and by the way, I acknowledge it's an extension of D'Orazio, but the best way to understand it is that a judge can choose not to sever, but if a judge chooses not to sever, and then a count that is not severed ends up being acquitted and ends up essentially being acquitted conduct, then at that point, that is a constitutional violation. So it's not the decision not to sever that was the violation, it's when that count becomes acquitted conduct and used, that's the constitutional violation later in time.
All right, your time has expired. I just want to see if my colleagues have any further questions. Thank you very much,
Thank you, Your
ADU
Honor.
Johnson.
Good morning, and may it please the court. My name is Melissa Johnson. I'm an assistant district attorney in Middlesex on behalf of the Commonwealth. And I'd first like to start with the ineffective assistance claim. And I will say without any question that the defendant has failed to sustain his burden on either prong of the ineffective assistance test. And the first one just being his performance. And we view this in terms of a tactical decision of the defense attorney. And the defendant has failed to show that it was manifestly unreasonable.
Well, do we view it through the manifestly unreasonable lens, where it doesn't seem from counsel's affidavit like he made an affirmative decision, an informed decision not to hire such an expert? It seems like he made a blanket decision based on his belief about the defendant's lack of financial resources not to pursue an expert. So he did. It's not as if he gave full consideration to an alcohol blackout expert and made a tactical decision that this wasn't going to work in the context of this case.
Right. Well, the trial judge here did find that in a footnote, she said the defendant didn't push the first prong issue, and she found in a footnote that this counsel's his performance didn't fall below that standard. And I think she, in a way, implicitly discredited that. And if you look at what the tactic that he went,
Discredited what?
Discredited the affidavit of this trial attorney, that he really didn't consider anything else. I mean, the fact of the matter is that he had a tactic here that was very logical. He had this victim who had essentially had sex with her friend's boyfriend. And so he was going to push the theory that she was motivated by remorse, embarrassment, in an effort to cover up this indiscretion, if you will. So that was a logical tactic that he went forward with, and I think that, in my brother's argument just before this, I think when you talk about what the effect that alcohol is going to have on a defense, it's fraught with problems, because you have a situation here where you have a defendant who's well aware that this victim was drunk, well aware that she'd been drinking throughout the night, was so concerned about her that he said that he was checking on her to see if she wasn't choking on her own vomit, and then proceeds to have sex with her. Now, it goes without saying that if you know someone is in that state, you probably shouldn't be having sex with them. So right there, I think the defense attorney was wise to stay away from any issues with alcohol as far as this victim. And in fact, and I want to kind of touch on what you and my colleague or my brother were arguing as far as the expert here and whether he would testify generally or specifically to these facts. I don't even think we even get there. I don't think we even get to the decision of the judge. Should this expert testify generally or specifically? Because the defendant hasn't even met that burden, that threshold, that this testimony would have even been relevant, whether it was general or specific to the facts. Because this affidavit, and this judge had just presided over the trial, where this victim had testified in detail about every single event that happened during that evening, from the moment that she was having dinner and went into Boston and the fireworks and every single drink that she had and what kind of drink she had, all throughout the evening in excruciating detail, the rape, and then after the rape, recounting that to her friend. So, even before we even get to the question of how this expert is going to testify, we have to ask ourselves, well, why would he testify if he can't even he can't even tether his opinion to the facts of this case?
Well, so counsel, though, defense counsel argues that there was a discrepancy between what she told the police immediately after and what she testified to at trial. What do you say to that?
Well, I would say to that, first of all, her memory was corroborated in detail by not only her friends, the witnesses, but also by the defendant. So every step along the way, there was corroboration of her testimony, of her recollection of every detail. And in terms of the police interview, yes, that occurred right after this rape. But that interview was really determined by the contours of what the police were asking her. She was probably traumatized and just was simply asking the questions about the rape itself. So, I think it's difficult. You're comparing apples and oranges a little bit, because we have an interview that's defined by the contours of what the police are asking her versus trial testimony where the prosecutor is asking her everything that happened from that afternoon all the way through the evening and the morning after. So I don't think that distinction is really without a difference here. But again, I think this attorney, looking at the tactics that he could have gone forward, the one that he chose was the most logical. If he had chosen something that had anything to do with alcohol or her suffering, from some sort of blackout, his expert would have been crushed on cross-examination, giving all the details that this victim remembered, because it's completely at odds with his affidavit of how someone would behave after this type of event.
Are you arguing performance now or prejudice?
I'm arguing actually both. I think number one, as I said before, this was not manifestly unreasonable to choose this tactic, but I think even more importantly, there's no prejudice here, because this expert would have, as I said, been crushed on cross-examination. It wouldn't have gone anywhere. And in any event, the defendant was able to kind of bring in a little bit of the alcohol in terms of her recollection of the events. He brought that in his closing and his cross-examination of the victim as to her ability to remember really what happened here, and the fact that she may have engaged in behavior that she later regretted. So he was able to bring in a little bit of that. So there really wasn't any prejudice here, because number one, this expert, had he even testified, would have gone nowhere in the jury's mind. And also the defendant was able to use a little bit of that alcohol related effect on the victim in his defense. And at the end of the day, we have an acquittal of 2 of the charges out of the 3. So clearly this wasn't lost on the jury. They were thinking very carefully about the facts. And the performance of this attorney was well above what the defendant could have hoped for, certainly with the overwhelming facts here against him. So if there are any questions further about the expert and the ineffective claim, I could move briefly.
Well, counsel, what I would just say is it seems to me that the tactic that was used by defense counsel and the one that's being proposed now on the motion for new trial both suffer from the fact that both would end up being a weak defense given the other 2 cases. Having a specific defense to one of the victims would be weakened in light of the other 2 cases that with the similarities being put forward. Mm-hmm. Now, in your brief, you argued it as a defense of the judge's decision to keep the cases together. Mm-hmm. Could you address it in terms of your brother's argument that having kept the cases together, the acquittals on the others constitutes a constitutional violation?
Yes, Your Honor. I think what my brother is trying to do here is basically extend the ruling in Durazio, which we know is already an extension of the federal rule, to a situation where cases are being tried together. There hasn't been an acquittal yet. So that would essentially eviscerate the joinder rule. If we can't try these cases together because there's a possibility that one might be acquitted, how are we supposed to join cases together that are related, that like here evince a pattern of conduct under Rule 9, if we take that rule to what the defense attorney here wants us to extend it to? So that's the practical ramification of what he's asking us to do. And I think it just doesn't make sense, because if you look at the reasoning for Durazio, it was based on collateral estoppel and the fact that, hey, these facts have already been heard by a jury. They've already heard them and they've said it's not true or it's not guilty or whatever. And the defendant shouldn't be punished for that. He shouldn't then be piled on, even though, yes, it's a little bit of a different standard with preponderance. We're not going to punish him for that. But here where we don't have that, the jury hasn't heard and ruled on the facts of these cases yet, then the Commonwealth should be entitled to, under Rule 9, as it is entitled to try cases together that are related, that evince a pattern of conduct like they do here, where the defendant is basically within a short time preying on women who he is familiar with, who he has ready access to, and that are in a position where they're either sleeping or drunk or both. And he's preying on them in a situation where they're asleep in their bedrooms, essentially. These related cases, the Commonwealth under Rule 9 is entitled to try those together. And if we extend the Durazio rule, we won't be able to do any of that anymore. Does that answer your question?
Yes, thank you.
If there are no further questions about either the gender argument or the ineffective argument, I would rest on my brief.
May I just ask? Oh, I'm sorry. Go ahead.
No, you go.
Yeah. Do you acknowledge that an expert can testify to principles without applying those principles to the facts of the case and leave that to the jury, contrary to what the judge ruled here?
Yes, I do, but I disagree. That's exactly what the judge ruled here. I think maybe she didn't do it in the most artful terms. I'm not sure. I think what she was trying to say is, and I do agree with it, your premise that a judge can testify to general principles without going into the facts of the specific case. What she was saying is, before we even get there, before I would have had to have decided whether this guy could have testified generally or specifically, I don't even think this affidavit is relevant. I've just heard a trial where the victim testified in excruciating detail about what happened to her from beginning to end of that evening. And I'm sitting looking at the defendant's submission. This has nothing to do with the facts that I have just heard. And the jury, and it would have been lost on the jury. So I think it's almost like more of a threshold thing that she was saying before we even get to the fact of whether his testimony or the contours of what his testimony would have been in trial.
Okay, thank you.
Thank you.
Any other questions? Then we'll leave it there. Excellent argument. Thank you.
The case is now being recorded.
Thank you. This is a continuation of the July 8th, 2021 sitting of the appeals court. We're calling our second case today, 2020-P-0615, Commonwealth versus Linkfist. If council could please proceed.
Good morning, Your Honors. Once again, for the record, this is Attorney Roberts Pavento for the defendant slash appellant, Mr. Lindquist. If it pleases the court, I would like to move in order of my brief. The first issue I would like to discuss, Your Honors, is whether or not the judge erred in denying the defendant's motion to dismiss based upon the no fix statute. We are arguing that the judge did err, and this warrants a reversal based upon this one issue to begin with. As you read in the brief and in the transcript, the criminal complaint was not issued until 3 days later. And while the police officer did write the citation that day, he did not provide it to the defendant, even though after he went in the ambulance, the officer testified that he met the defendant at the hospital, had a conversation with them, and for some reason decided not to give him the citation then and there.
So counsel, I just want to pause you because both of you keep using words that are not entirely precise. So when you say he wrote the citation, you mean he wrote out what it was and signed it, right? Am I understanding you correctly?
Yes, I apologize.
No, it's okay. And because the Commonwealth uses issuance and I don't know what that means either. So we'll get to them. So when you say he wrote it and signed it, like, do we know if he put it in the mail that day or we don't know?
Okay, so the defendant did not physically receive the citation that day. That makes a little bit more sense.
Yes, but I'm also concerned because I'm not sure that we know from the record when the defendant did receive the citation. There's a reference in his affidavit, but what authority allows us to consider his affidavit?
Yeah, so in the affidavit, Your Honors, that it does say that he did receive the citation 1 to 2 weeks afterwards. Even if you don't find that enough, knowing the police report, which was attached to the motion to dismiss, does it say that the officer actually issued him and provided him an actual copy of the citation that day. And there was no reason for him not to physically issue him the citation in hand that day.
But something was done with the citation that day.
It looks like, yes, Your Honor. It looks like the officer provided it, but did not issue the citation in hand to the defendant that day. But yes, you are correct.
But what is your position as to what do you agree happened with the citation that day?
What I would agree that happened, the officer testified that first the officer talked to him in the ambulance, and then he went to the hospital. He had a conversation with the defendant at the hospital, but for some unknown reason, he did not physically give him in hand the citation that day. It looks like he placed it in the mail, and according to the affidavit, which I believe the court should weigh at least somewhat, that he did not give it to him that day.
But he filed the citation in court when, the next day?
It looks like the complaint was signed 3 days later that Monday.
Okay, so the next business day.
Yes, Your Honor.
So if you look at the two purposes of the no-fix law, in terms of notice to the defendant, he was told while he was at the hospital, if not before, exactly what he was going to be cited for, and that is in fact what he was cited for. And if you look at the purpose of ensuring that there's no manipulation or opportunity for payoffs or whatever it might be with respect to whether a citation will issue, it was filed promptly in court at the next opportunity after these events. So I don't see how either of the purposes of the no-fix law has been frustrated here.
My argument, Your Honor, would be that even though he did have some form of notice, the way I interpret the statute, I think the way that the statute should be interpreted is that he has to have actual physical citation in hand. For some reason, also I always like to put your attention to is during this argument, the Commonwealth did not make any argument for the issues of the lack of following the statute. Probably because of that, their argument should be waived. But in any event, Your Honor, I believe the O'Leary case is very clear that at the time and place of the violation, that he should be receiving the citation in hand. And because of that, I'm arguing that the judge erred and should be reversed on those grounds. I know it's a little bit different than O'Leary.
Right, in what way is it different from O'Leary?
The biggest difference between this case and O'Leary is the time frame. I believe O'Leary is 9 days that the officer didn't enter it. There's the lapse of time. But there doesn't seem to be any case law directly on point when the actual date must be filed, whether it's 2 days, 5 days, 9 days.
But doesn't the case law, in fact, say that each case has to be decided on a case-by-case basis?
Yes, that makes it a little more difficult for everybody, but yes, Your Honor, it does say that. So it does give a little bit of interpretation for you to decide on that issue. It's also different. I don't see an anti-abuse issue. I don't see that the citation, it doesn't seem reasonable that the officer would go to the hospital and for whatever reason decides not to give it to him that day. I don't want to keep repeating myself over and over again. I think you, unless there are other questions on this issue, Your Honors, let's move on to my second issue. Is there any other questions? Okay. I believe, Your Honors, the second issue I discussed in my brief was on the day of trial, the Commonwealth provided the defendant notice of an expert who's going to testify on a different theory. While it's the same expert with the state police, the Commonwealth never provided the defendant with adequate notice.
I'm sorry, was it a different theory? I mean, wasn't it, wasn't the criteria, the expert, you know, how you label the expert? Wasn't
Yes.
really?
That's the way I phrase it, but the way, so originally they were going to use that officer as a DRE expert, but because he was not present at the scene, he would not be able to testify as a DRE because one of the 12 steps is that the officer is actually there and could testify of the reactions of a possible drug overdose. In this case, in the morning of trial, they use a different theory, which was he's going to testify as a medical expert.
Well, just to be clear though, 6 months before trial, they said, we're going to call this named person and he's going to give XYZ testimony. And he's going to be qualified as a DRE. And then the day of trial, they still called that person and he was still giving the XYZ testimony, but he was being qualified in a different area, right? Is that what happened?
Yes, yes. So the biggest argument why this was an error, Your Honors, my first argument that this was a constitutional error, that he was denied a fair trial. I briefly will discuss that. So on the morning of the trial, they say, okay, we're using this expert, but on a different issue, not based on DRE, but on a medical expert. The defendant objected multiple times. At one point, the defendant says, I strenuously object. And you see it in the transcript, the judge even writes, I accepted you strenuously object, but we're going to go for trial.
But I think the question is, where's the prejudice? What would have been done differently on cross-examination if the Commonwealth had listed this witness earlier, not as a DRE witness, but as a medical expert witness?
It would have provided the defendant a much better opportunity to prepare for his case.
Well, specifically, what would he have done differently?
He could have called another expert on his behalf. He could have prepared much better with the case. As you read the transcript, the case starts approximately 9 a.m. or so. It goes through the normal ordinary parts of a trial and they give him the notice of this new expert who's testifying a different theory. And the judge does not give him any time to even look over the paperwork.
Well, but the judge indicates that he would give him time if he wanted, and the defendant didn't want it.
I respectfully review that in a different light, Your Honors. When you read the transcript, he starts objecting on page 3. And then he objects again, I believe, on page 20, 42, and 49, over and over again. He says, I object, I object, I object. And at some point, I think the defense attorney, he's stuck in this position. He's objected, but there's not much more he can do. He's not like, forgive me for this, it's like as a judge, I refuse to go forward in this case. He tried to do the best cross-examination that he could. He continually objected. He knew that he was being prejudiced in a major way. And that prejudice is that he was not being able to adequately cross-examine. The defendant did not have an adequate ability to defend himself. The Commonwealth states in their brief that the defendant almost, I guess they say, he acquiesced and didn't object. But that's not entirely true. He did object over and over and over again. There comes a point in time when the judge says, no, we're going for trial. And what is the defendant supposed to do at that time? He just keeps on objecting to preserve his client's constitutional rights to a fair trial.
What do we do with a situation where the judge is asking him before trial commences, do you need a continuance? And he's indicating no. And then the trial commences and he's objecting. I mean, at that point, there's a moment where you say, I need more time, or you don't.
I believe, Your Honor, his first objections, he stated, he says, Your Honor, so we're going to have another day in this, correct? And the judge says, no, I'm ready to mark this for trial. So then they go through the proceedings. The prosecutor once again says, I moved to have this expert in the voir dire. The defendant again objects. And I believe he objects 3 or 4 more times. I understand what the Commonwealth is saying, what you're trying to say, but I honestly believe that he did object properly, and he was stuck in no man's land, with either refusing to have a trial that day or going forward the best way he could, which I believe that's what he did. If I didn't believe he did an adequate job, I would have considered it ineffective assistance issue, but I don't see that at any point. The judge did not give him any opportunity to review anything either. The judge basically just said, okay, counsel, we're ready. Let's get this case. I'm ready to try this case today. And more interestingly, Your Honors, is during this discussion, the Commonwealth tells the judge, says, Your Honor, we had something similar like this yesterday, and you allowed us to continue it. But for some reason, in this case, which is almost the same facts, at least according to the transcript, the judge did not give the defendant a short continuance. He did not give him any time to review. And I know I'm starting to lose time. A couple of things I would like to discuss. The Commonwealth states that this is not a constitutional issue, but rather an abuse of discretion issue. Without waiving my constitutional argument, I would say that it's definitely an issue of judge abuse of discretion. I'm not saying that the judge didn't know what he was doing, it was incompetent or anything like that. But what I'm saying, Your Honor, is that he didn't weigh the factors properly. On one hand, you have the Commonwealth, who has a witness who's going to testify at least on a different issue between DRE versus medical experts. And all the Commonwealth would have to do is either call that witness again and re-prepare. While on the other hand, you have a defendant who's charged with a OUI third offense, and if he's convicted on that, the judge must send him to jail. He does not have any discretion to send him on probation or even reduce it to a continuance without finding or anything of that nature. The judge is stuck with having to send him to jail, which is a mandatory 6-month jail sentence. So that's why there's an abuse of discretion. He did not weigh the factors properly. And I know almost out of time. I don't know if the panel has any questions. If not, I would rest my brief with the third issue.
Thank you.
Thank you, Your Honors.
ADA Sullivan.
Morning, Catherine Sullivan for the Commonwealth. This case has a lot of moving parts, and I appreciate the panel's attention to the details of each one. There are 3 separate proceedings and 3 separate findings by 3 different judges, so it is a lot to take into account. What has not been said, which I believe is the elephant in the room, so to speak, is that here the defendant was at a minimum dying when Officer Wood came upon him, if in fact he wasn't dead already. And only by virtue of the officer's actions and immediate actions did he survive. It's telling that in the defendant's trial counsel's affidavit in support of his motion to dismiss, he makes no mention of the Narcan delivered to the defendant that allowed him to survive. So that's one issue. With regard to I'll try to take the questions and issues raised by the defendant in order, though the court has pretty much addressed them already. I'll just add a few insights to them. With regard to the motion to dismiss, Justice Singh is right that the case law is, unanimous in holding that these cases have to be viewed on a case-by-case basis, where the circumstances are virtually all incredibly diverse and different. And in my research, preparing for today, I could not find one single case where the officer issued a citation that same day or the next business day, and the case was nevertheless dismissed. In O'Leary, it was a matter of 9 days, and there was an issue of a supervisor being involved with regard to issuance of the citation, which the court specifically called out as prohibited by the statute. And in Wera, for example, which is cited in my brief, it was also a matter of months, and not only months transpired, but they changed the nature of the charges issued. That was not the case here. In Burnham, also where the finding of the motion to dismiss was held up, it was 4.5 months. This is more akin to the case of Moulton, the 2002 case, where there was an OUI and the officer told the defendant that he would be issuing that and then did so later. And in that case, the court specifically said that in any event, a complaint need not be dismissed where the police have not been slothful or inattentive to the statutory requirements and the basic objectives of the statute have been met. And I would argue here that Officer Wood was more than attentive to the requirements of the statute. He did a remarkable job at the scene. He went and checked on the defendant at the hospital. We know later on from his testimony at the other proceedings anecdotally to verify his identification further. And then at that point also told the defendant that he would be issuing the citation for which he did issue, in the exact nature of which he did issue. And as to Justice Henry's question regarding issuing or mailing or signing or filing. I don't know the specific, I guess, definition for each distinct term. I will say that at the motion to dismiss, the judge relied and the parties relied solely on the police report. And in that police report, in paragraph 5, the officer says that he told Mr. Lindquist what the nature of the citation he would be issuing, and that he faxed that form to the RMV. And then we have the citation noted the next business day. And we also have Mr. Lindquist in his affidavit saying he received the citation 1 or 2 weeks later. So we can presume from that it was mailed the latest date, that following business day, that Monday, and he received it later in the week. If there are no questions.
We're crystal clear on the facts on this. You agree that the defendant did not receive a copy of the citation that day, like in person anywhere?
Had the defendant received a copy of the citation that day, there would have been other issues raised by that, by virtue of his inability to even be aware of what was going on during these events or immediately after these events. So of course we agree that the citation was not issued at the time and place of the violation. However, if these circumstances don't warrant mailing a citation rather than handing it to a defendant at the scene, I'm not sure what circumstances do. We also know anecdotally from Officer Callahan's testimony at trial that the effects of Narcan wear off. So there has been some action to maintain a hold on victims or defendants in this case that have been giving Narcan, because after 12 hours, maybe their awareness will start to slip by virtue of the drugs they had ingested that caused the overdose. So,
Right.
and that, of course, the judge didn't have that at the motion to dismiss. That's just something that we learned later on.
Right. And we also know that, do you agree that the officer had completed his investigation by the time he saw the defendant at the hospital?
I'm not sure. I think that there's anecdotally, again, it's not reflected in the police report, but he certainly testified that he went to the hospital for 2 reasons. One was to further verify his identity and make sure that the victim, the defendant, was the same person whose picture he had seen when he ran the license at the scene. So his investigation was ongoing at that point also. But the judge certainly, in the motion to dismiss, did not rely on that in her ruling. So that's an additional factor that this court can certainly consider. But as I said, that was not reflected in the report. I think it is remarkable that the officer had the ability to notify the defendant of the nature of the citation at that point, and he did. And then those are the charges that were specifically raised in the complaint.
You placed an inventory form in the supplemental appendix, but it's my understanding that that was never introduced to the motion, Judge. Is that right?
That's correct. And I did it just in order to, to present the completeness of the record. I'm not sure why it was not included. Certainly it was part of the record. I'm not sure why the prosecutor didn't introduce it at that time, but I thought it only fair to alert the court that it had been filled out. So that speaks for itself. With the motion to suppress, I rest on my brief from that. With regard to Officer Callahan, Justice Sachs hit the nail on the head with regard to that. I'm not sure where there's any prejudice to the defendant. In fact, at trial, one of the issues he kept hammering Officer Callahan, about was that he wasn't present at the scene in order to interview or assess the defendant. And that would have been the same had he testified as a DRE. I strenuously disagree to the defendant's characterization of counsel's continuing objection. His continuing objection was to qualifying Officer Callanan at all, rather than to going forward. And it appears from the record, and I've included that portion of the record in my SRA. It's at SRA 68. The trial counsel says, all right. When the judge says, let's do it, trial counsel says, all right. If that's not acquiescence, I'm not sure what is. And then he says, but to be fair, in order to be fair, I want you to give you an opportunity to review everything you received. And trial counsel says, yeah, as you know, agreeing again. So, and I'm not sure what there is different that he could have reviewed in preparing for trial, frankly. Nothing new was presented to him other than, you know, a crossed out designation from DRE to medical expert. And the quality of Officer Callanan's testimony was certainly extremely high. And that's not a basis for the defendant to claim either prejudice or somehow wrongdoing on the part or lack of notice on the part of the Commonwealth. So if there are no further questions from the panel, I'll rest on my brief.
Anyone else? Thank you very much.
Thank you.
We understand your positions and the case is under submission.
The case is now being recorded.
Thank you. This is a continuation of the July 8, 2021 sitting of the Massachusetts Appeals Court. We have our third case on for the morning. Case number 2020-P-0218, Commonwealth versus a juvenile. I do just want to repeat that if you see us looking off to the side, it's because we have our notes on a different screen than the one where the Zoom camera is. We are very much paying attention to you. We just sometimes need to refer to our notes. And I also want to assure everyone that we are very familiar with Counsel Rosnoff.
Thank you. Good morning, Your Honors. May it please the court, Attorney Elena Rosnov on behalf of the juvenile. Your Honor, this is a very narrow issue. The juvenile argues that there was insufficient evidence for the jury to find that he committed the offense of an indecent assault and battery on a child under the age of 14, and that the case should actually have never reached the jury and had been dispositive on a required finding. Your Honor, this is Your Honors, this is an incident where where the juvenile was babysitting and changing the diaper of his minor half brother, who was 1.5 years. There was little testimony surrounding the actual video of what was seen in the incident, but the video itself was played for the jury. As pointed out, the video did not depict the juvenile, the minor juvenile, the 1.5 juvenile's genitalia. There was some.
But the video does depict the defendant, juvenile, putting his hand between the legs of the minor child. After he's finished the usual operations involved in changing a diaper and moving his hand up and down 5 times.
So I believe that was what was inferred, is that was the portion that that was what.
Could a jury reasonably infer that he was touching the child's penis?
I would suggest, Your Honor, that the jury, we don't know what was going on. It looked as if he had swatted or moved once he had finished doing what he had thought he had done, and credibly, the mother testified that she taught the defendant juvenile, I'll call him, how to change the diaper, but that he had never done it alone, and he had never done it by him. This would have been probably the first time that he had done it alone and by himself.
Yes, but I didn't see any argument by defense counsel or in your brief that the motion that he could be seen making was any part of the diaper, an ordinary diaper changing operation. He wasn't wiping the child's penis off. He didn't have a wipe in his hands. What was he doing that was a part of changing a diaper?
I believe that defense counsel did argue, and I did make reference in at least the small portion of the fact session, because it wasn't, as I had stated, it wasn't a very long argument. It wasn't a very long cross-examination of the juvenile.
He could have seen something that he missed the first time, but could a jury reasonably infer that moving his hand up and down 5 times is not consistent with cleaning something that he had missed?
A jury could infer that, but also, Your Honor, the jury didn't see him actually physically taking a wiping. That is not what it depicted. In fact, all that was inferred is that there was a smell. I'm going to change your diaper. Ew, which quite frankly, if you're a 16-year-old boy changing the diaper of a 1.5-year-old isn't a completely inappropriate response. There was no testimony about the size of the mess. I mean, we're talking.
But he does use wipes to clean up the child's genital and anal area before he puts on the new diaper.
And then he switches to the new diaper, puts the new diaper under him, and a jury could reasonably infer that maybe it wasn't all cleaned in the moving of the again, we're surmising, but I think that just sort of lends hand to the fact that there isn't enough evidence to show what exactly went on. I think the jury could have also inferred that the minor child isn't heard yelling, screaming, protesting, even giggling, or making any sort of I guess gestures that he was uncomfortable or that he was being hurt or that something was tickling him. I mean, there was just none of it. Was a very short, very a very short period of time that this happened. And I would suggest to you that, moving a child's genitalia, especially a boy, if you're changing a diaper, and again, we're all left to conjecture as to what the mess was, what was actually happening, but to suggest that the defendant juvenile was doing something indecent or inappropriate by moving his hand somehow. I don't know how, and it's hard to tell from the video how the child was positioned. Was the child squirming? And I think that defense counsel obviously.
I think the issue though is that the jury had to decide whether the touching was indecent, and maybe some people would conclude that the juvenile was behaving in a juvenile way rather than in an indecent way, but that the jury could conclude that he behaved in an indecent way, and that's really a jury issue and not for us to overturn. So what do you say to that?
I would suggest that the case law suggests, and that the court should consider the case law that says that the test for the indecency is an objective one, and it turns on the nature of the juvenile's conduct. And his conduct was that it was perhaps immature and perhaps juvenile, but did it rise to the level of criminal conduct? Did it rise to the level of intent such that he could be charged with an indecent assault?
Well, in that connection,
case on that, and then answer Justice Sachs's question.
Sure. I believe I cited in my brief, the best case I have on that is Commonwealth versus Levine, which is at 42 Mass App Court 313. It's a 1997 case. And I believe I also cited Commonwealth versus Castillo, which discusses the circumstances of the touching, which is at 55 Mass App Court 563. And
so where the test for indecency is objective and doesn't turn on the defendant's intent, I didn't understand why on page 13 of your brief you were talking about specific intent. Is any intent required to be proven here other than that the act of touching the child was intentional and not accidental? There doesn't have to be any proof that he intended to touch him in an indecent manner or for a purpose of sexual gratification or giving offense to the child or accomplishing any other goal. As long as the touching itself was intentional, what other intent has to be proven?
Well, my understanding of the case law was that the case law has established that indecent touching is one that it's fundamentally offensive to contemporary moral values, and society would regard as immodest or improper because of the sexual overtone of the touching. And I don't believe that we've established that sort of the sexual overtone of the touching. Give me one moment, Your Honor. I did write something down as we were talking.
But counselors, if this were an adult, that very motion, there'd be no question that it would be viewed as indecent, correct?
I'm sorry, I don't understand your
The
question.
very motion that of what the juvenile defendant was doing.
If he was an adult,
The baby was an adult,
if the baby was an adult, I'm sorry.
right? So it's
Again, I don't know, because again, this video doesn't depict any showing of the area. I don't know what the juvenile's hand motion was doing.
okay. So
I don't even know that the juvenile had his hand on the child's penis, and the video doesn't depict it, nor does the Commonwealth's brief suggest it, that his hand was actually on the genitalia when this up and down motion was going.
okay. So I wanted to be clear about your arguments. You're saying that from the video, it cannot be inferred that the juvenile defendant was touching the baby's penis.
Right, at the time of the up and down.
You're saying that cannot be inferred from looking at that video.
I'm saying that, well, could it be inferred? Sure, but again, you'd have to also take it a step further, and I guess the jury would have to have been reasonably assured that the juvenile defendant's hands were actually on the genitalia of the minor child, and we just don't see that. So I think that it's close, but I don't believe under these circumstances with these facts that it should have made it for a jury's question. I mean, for a jury to answer.
So can you explain what, just to come back to my prior question, on page
Sure.
13 of your brief, you talk about specific intent. What specific intent was required here?
So it's my understanding that in order to secure a conviction for an indecent assault and battery on a child under the age of 15, on child under the age of 14, that there has to be an intent to actually touch indecently that person, and a
Okay,
specific.
so what case says there has to be an indecent intent versus merely that the touching itself is intentional, and then the indecency is judged not by as the Levine case said, and you acknowledged a moment ago, that the test for indecency is objective, turning on the nature of the conduct rather than the defendant's intent.
So I cited in my brief Commonwealth versus Gunter, which discussed that the defendant must have consciously intended to take certain actions, and that he also consciously intended the consequences of his
Well,
actions.
that's where specific intent is required, but I'm saying what case requires specific intent in an indecent assault and battery, other than that perhaps the intent to touch? I'm not even sure that constitutes a specific intent.
And Your Honor, I apologize. I don't have one cited in my brief, and I'm happy to follow up with a 16L letter. I'm sorry. I'll have to follow up on that. Thank you. And if there are no further questions, I'll rest on my brief with 3 minutes left.
Thank you.
Thank you.
ADA Jensen.
Morning, may it please the court, Catherine Jansen for the Commonwealth. The Commonwealth respectfully requests that the court affirm the juvenile's conviction, or I guess finding of delinquency, for indecently touching his 1.5-year-old step brother or half brother. We have to look at this in the light most favorable to the Commonwealth and what reasonable and fair inferences the jury could make from that video. And from that video, which I have moved to transmit to this court, which
we have the video.
Seems that the court has watched it. So based on what the jury saw that the juvenile knew how to change the victim's diaper appropriately and did so with wipes, with baby powder. And then when he put on a new diaper underneath him, put the top of the diaper over him and sat there and then pulled the diaper back and stared at the victim's genital area for a few moments before putting his hands between the victim's legs and moving it up and down as if he was tugging at the victim's penis. And from that, the jury could reasonably infer, even though you can't see the victim's genitals based on his bent leg, a jury in their common experience and common sense and life experience could definitely infer that he's touching it in that instance. As well as,
do you agree though with Justice Sachs that it's an objective determination whether the touching was indecent?
Yes, I believe so, because it's based on what the fundamental norms are and what's fundamentally offensive to society. I'm not setting the standard exactly word for word, but that's the gist of the standard. I believe it's you need to intend to actually do the touching, not that you need a specific intent. And I think that's to differentiate between cases where, say, I'm walking by somebody and might accidentally brush my hand against somebody's rear end, opposed to actually intending to touch it. So I think that's the distinction. That's not specific intent. I think it's you need to intend to actually do the conduct.
Well, let's just hypothetically say that you have a teenager who seemingly has just learned how to change a diaper and is perhaps surprised that a baby boy can have an erection and is just exploring that and does not in fact have a sexual intent when he does that, and he's just being a teenager. Would that be sufficient to sustain the finding of delinquency?
I think it would, because that would be the intentional, unjustified touching of a private area. That's all that's required.
But
just because you're curious doesn't make it not.
But it has to be for an indecent purpose.
I don't believe so. It just has to be an unjustified touching. So an unjustified touching here, the touching was justified when he was changing the diaper. It becomes unjustified after everything appropriately attendant to the diaper change is done. And
the question whether a teenage boy who's curious and surprised seeing a 1.5-year-old get an erection, if that's what happened, whether that is indecent is judged not by the teenager's intent, but by objective standards of whether society would consider a touching in that situation to be indecent and inconsistent with contemporary mores and so forth.
Yes, Your Honor, that's my understanding of the law, that's how it would be judged. And I think here, based on the video, the jury was more than reasonable, could find that what he did in touching the the victim's penis in this manner and then swatting at it twice afterwards, either one of those instances would be indecent and inappropriate and unjustified touching.
Is there any specific intent requirement in this case? What about the intent required for the touching? Is that specific intent?
I don't know if that would be specific intent. I think you have to, I think it's a general intent. My understanding is that it would be a general intent crime. You need to intend, you have to intend your conduct of intending to do the touching, but there's no specific underlying specific intent to that, for sexual gratification or any other reason. That would be my understanding of the case. And if this were, as Justice Singh noted, if this were an adult, I don't think we'd even be having this conversation. I'm the rest of my brief.
Did any of your cases in your brief address the issue of general versus specific intent? I know you haven't pulled them out that way, but are you aware of any that does?
Not that I'm aware of. Most of the cases that I cited are big general cases about what constitutes indecent assault and battery, and based on that objective standard of what's fundamentally offensive to norms. I view that as an objective standard. I didn't read the cases for specific or general intent, and I apologize to not being able to answer that question. I don't remember that being discussed in any of the cases. That doesn't mean they weren't.
Thank you.
I'm happy to answer any other questions or rest on my brief.
Seeing no further questions, the case is submitted. Council, thank you.
The case is now being recorded.
Thank you. This is our fourth case on the July 8th, 2021 sitting of the Appeals Court. Matter number 2020-P-0699, John Doe number 372711 versus Sex Offender Registry Board. As you counsel have both argued on Zoom, this is as if we are in a courtroom. Each side has 15 minutes. There's no rebuttal. And I do always like to say that if you see us looking off to the side, it's because we have one, or in my case, two other screens where we are reviewing your materials. So we are focused on your argument. We're just looking at our notes to make sure that we get to ask you the questions to help us resolve your case. So with that said, Attorney Burkholder, please proceed.
Good morning, Your Honors. Your Honors, this is a case with a set of facts where I think that we're all going to face quite a bit in the near future. My esteemed brother and I spoke yesterday, and as a result of the decision by Judge Wilkins in the Middlesex Superior Court in 22188, and the board's concession that they are bound by that, we fortunately both anticipated that to occur and addressed whether or not there would be substantial evidence in support of the classification if factor 2 was excised. So I'm pleased to announce that the majority of my argument is contained within my brief, and I'm prepared to rest upon that only with a few minor comments and of course responses to any questions.
Can I ask get clarification on that?
Yes, please.
So should we approach this case as we can put aside the ineffective assistance arguments regarding failure to challenge the application of factor 2 in this way or that way, and just ask whether, take it as given that factor 2 should not have been applied here, and then ask whether the case nevertheless can be affirmed or needs to be remanded? I see Mr. Bosse nodding. Is that your understanding as well,
Yes.
Mr. Burkholder?
Yes and no, Your Honor. Yes, with regards to factor 2. No, with regards to the two other matters that I raised before the Superior Court with regards to ineffective assistance, those being the failure to develop mitigating evidence and the failure to pursue a motion for fund.
Okay, thank you. Good.
And in that regard, before I go back to factor 2, I'll just speak very quickly with regards to those issues. The issue ultimately becomes, in this case, prejudice. Whether or not there would be a material effect upon the decision, whether there's substantial evidence to support the classification minus factor 2. Because of that occurrence, then the importance of the other errors that occurred at the hearing level are magnified, in my opinion. Specifically, my esteemed brother emphasized significantly in his brief that there were no mitigating factors that were considered in my case, in contrast to 22188, which I rely upon, and also that existed in 23656. As you may recall, in my brief in motion before the appellate court or the Superior Court, I indicated that part of a attorney's responsibility is certainly to marshal the evidence. And you can see from a view of the transcript and the correspondence between SORB counsel or hearing counsel and the board, for whatever reason, hearing counsel was having some issues during that period of time, whether it be with his equipment, whether it be with family matters or otherwise. He did indicate that he spoke with my client's mother. That's important in this case for the following reason. That individual owned a business, and my client worked at that business previously. And undoubtedly, he was going to have the support of that individual in the future. He made every representation to me that he would return to that business, and that would provide him with support in the form of support in the community, plus support from the family, employment, all the factors that go to the issue of antisocial personality, which I'll get to in a moment with regards to the studies that are discussed.
But counsel, where in your brief do you argue that there was ineffective assistance for failure to develop mitigating evidence?
You're going to have to open it up and read through it, and we both can do that at the same time. But I believe I indicate there was a list of things that occurred, and it certainly was raised before. Well, let me see. It might be in the very first subsection. Yeah, it's in the first subsection, and I didn't unfortunately print that portion, Your Honor. I can pull it up if you wish. But in essence, I believe, well, here my arguments were Superior Court committed abuse of discretion in denying Doe's motion for relief from judgment due to the ineffective assistance of counsel. I raised that in my first argument starting at page 24 of my brief. And then I go on to mechanical application, and then fair to sufficiently explicit efficacy of internet and the like. So I would have to pull up that argument again, but I've got to believe that I argued that because I argued everything that occurred there. And the primary.
Well, you say there were three ways that counsel was ineffective. One was factor 2, one was failure to develop mitigating evidence, and what was the third?
Well, there were lack of studies. There were a number of things, Judge. And I'm embarrassed because I don't have it up, but I certainly can pull it up here in 1 second and tell you what it said. If I can get to that screen. Let me see.
I don't want to throw you too much off your argument, so.
Well, yeah, I'm used to it. That's fine. That being here, I got it. Thank God for electronics.
Indeed.
Okay. I talk about.
What pages 25, 26 have a list of 6 points on which you claim ineffective assistance. The first 4 deal with factor 2. The 5th has to do with failure to introduce scholarly articles. And the 6th is failure to insist on an explicit finding on internet dissemination. So I'm not seeing failure to develop mitigating evidence in there.
Oh, well, let's see if I might have mentioned it in passing in the remainder of the argument. Did I set it out? Let's see. Oh, I can't believe it. If I didn't, I'm quite surprised, but we'll see. Factor two, explanation, authority, Dr. Hanson. Well, I may have run out of space. That's, if it's not there, it's not there. Then I follow my sword and I failed to do so. The reality is going back to the list that I provided.
So the board argues that even if factor 2 is taken out of the equation, there was no reasonable probability that Doe would have been classified lower than a level 3 because of the other high risk factor. What do you say to that?
Well, I mean, the only thing I can say is I love the comment that was made by, I'm just not very organized today for some reason. I love the comment that was made by Judge Wilkins in the Middlesex decision, which in essence he says, it's the decision of the hearing examiner to and the bailiwick of the hearing examiner to make the determinations, to weigh the factors and the like. And what I say is first of all, that's where it should be done. Secondly, all I can do is compare with the existing decisions that are out there. And the two most prominent are 23656 and 22188, both of which involved rapes. And although they involved some mitigating evidence, it was nominal. And both had, interestingly, both had SDP evaluations that were considered, and they ended up level 2s. And here we have, I'm not going to dispute that we have an adult offender with a child victim, but I do want to say, quickly that the victim in question here was not, although not the existence of no factors, I certainly understand is not, supportive of a lower classification, but we don't have a pubescent victim. And secondly, I think it's really important to look at in the context in which this occurred. The offense was egregious. There's no doubt. I have daughters. Anybody that you have situations where you have minor children that are put in a position where they have to engage in this type of activity and the like, I don't condone it in any capacity. What I go to with regards to that is what I've seen in other cases and is supported by 205614, and that is the board on numerous occasions have given me funds to determine whether or not there's a deviancy component to the other aspects of what occurred here. And I think it has to be looked at in the context of, we have an individual who was this age, who one individual left, the other individual did not leave. I'm not at all blaming her and saying she was responsible, but I'm more importantly looking to see the degree of deviancy that exists when you have a financially motivated offense. And this was all in the context of that occurring. So, and that's your only other high risk factor. Extrafamilial, I think, was very generous of the hearing examiner. Certainly was alcohol and substance abuse, minimal weight. The contact with the criminal justice system, I can even accept.
Can I ask you this? If we were to affirm, would Doe be in a position to seek reclassification?
He'd be past the 3 years, yes.
And how, if at all, should that weigh into whether we remand here or affirm based on the essentially holding the application of factor 2 to be harmless?
Well, first and foremost, although a hearing examiner is not supposed to look at the prior class, first of all, it's his duty to start with to show that there's been a change of circumstance. And secondly, you're up against a decision that is not valid. If you look at this decision, it's back from 2017. So it's before clear and convincing. It's before 496501. There's no determination of the three prongs.
Wait, this is not before clear and convincing. I mean, the hearing examiner applied that standard.
Well, okay, maybe it's not before clear and convincing, but it's before, what's the date of the decision? It's before 496501 and the requirement of an establishment of dangerousness and efficacy of determination and the like. It's 2017. It's an old decision. So it doesn't have the benefit of that. I just think that if this individual is stuck with that classification, to get through the system, to do reclassifications now, although I don't have the statistics in front of me, I think my brother would agree with me. It's taking some time to do that. And if this individual should benefit from the change in the law or the establishment that the law was unconstitutional as it was applied. And when you take that out of his case, he doesn't have as egregious case as many of the offenders that I've represented. I've got guys with multiple rapes that are level 2s. This guy's at a level 3. That's a pretty egregious, and especially with no development of deviancy. I really think that there's a need here for psychological evaluation and determine whether or not there's deviancy present, or he was just an individual like in 205614 that was making money and he got involved with a 15-year-old girl, and what occurred thereafter certainly wasn't condonable, but nonetheless, this was not a forcible rape.
How much certainty or uncertainty must there be over whether factor 2 was outcome determinative here in order to warrant a remand? What's the standard?
I got a decision yesterday from this court that said the standard was whether or not the excise materially affected the determination. That's the standard that I'm that I'm relying upon, whether there's a reasonable probability of a different result. And I think there is a reasonable
But is
probability.
that an ineffective assistance standard, or is that a 30A standard, or where does that come from?
That's the standard that was applied by this court yesterday in a decision. Decision was 457-20 P457. I actually got the decision 2 days ago. Doe 2453. And the court determined that basically they said where is it? Let's see. On this record, we cannot be confident the result did not materially affect the outcome. And that was an excision of factor 2 case. And the case was remanded back. And there was also no determination of efficacy in that case. And that the court ordered for the remand hearing examiner to consider that as well. So that's the standard that I'm relying upon. I frankly believe it's the same standard for ineffective assistance to counsel. Under Safarian, we have 2 tests. We have the existence of an error, which I don't think anybody disputes in this case, including the Superior Court judge or my brother. The question is, was there prejudice? And prejudice, as we all know, is whether or not there was an effect upon the outcome. You take out factor 2, I still think, and maybe I waive those arguments, and maybe my client has a motion to vacate case against me, which is fine. If he does, then I'll sign an affidavit accordingly. I think that those issues need to be developed, and you really need to take a look at, understand, and remember. In the 2 other cases that are cited both by myself and my brother, deal with the existence of psychological, whether or not there was STP, and there were reports that were introduced and considered. They were considered under factor 35. I'm sorry. So here we could benefit from that.
All right, counsel, we'll have to leave it at there, and we'll now hear from Attorney Bossé.
Thank you.
Morning, Your Honors, and may it please the court, John Bossé for the Sex Offender Registry Board. Because the good counselor from Boston did a good job of arguing below of that hearing counsel was ineffective for failing to challenge the validity of factor 2, much of my brief focused on the prejudice prong under the standard review for ineffective assistance of counsel. And essentially my argument is that even when you take out the hearing examiner's application of factor 2, substantial evidence continues to support the examiner's decision to classify the appellant as a level 3 sex offender. And that is based upon the fact that there is still a high risk factor of factor 3. And in this case, the appellant not only sexually assaulted a 15-year-old victim, but he also prostituted a victim who was 15 and 16 years old.
Well, let me just interrupt you if I might. Substantial evidence might support a level 3 classification, even if factor 2 had not been considered. It might not. But the question for us is substantial evidence is a deferential standard of review. The hearing examiner is supposed to be the one who has the expertise and applies the expertise embodied in the board's regulations. The hearing examiner might have said this person should be level 2, and we might uphold that as supported by substantial evidence. So just because the evidence might be substantial enough to support a level 3 here doesn't really answer the question. What would the hearing examiner have done without factor 2 in the case? How do we know that?
Right. So I think the SWEB's best case for that is the 496-501 case, which we refer to as the explicit findings case. That was the 2019 case from the Supreme Judicial Court in which they said that the hearing examiner has to find 3 elements, including whether internet publication is warranted. And in that case, one of the issues was whether the hearing examiner committed error by applying factor 24, which addresses the failure of a sex offender to participate in sex offender treatment. And they said that the examiner did commit error by applying that factor, but they said that even when you take out the factor 24, substantial evidence continued to support the offender's classification level in that case, which
So
was.
what is the standard? You think the standard then is whether substantial evidence still supports the classification even when we exclude factor 2?
Yes, based upon my reading of that 2019 case, I don't think, I apologize, because I was focused on the second prong of ineffective assistance of counsel. I didn't cite that standard in my case, but I do cite the case in my memorandum, and it's that 2019 496-501, and it's basically a prejudice argument. They said, even if you exclude, certain evidence, in that case, it was, if you exclude a regulatory factor, there was still substantial evidence to support the hearing examiner's decision.
So you think that that your opposing counsel is incorrect when he says the question is whether it would materially affect the outcome?
Correct. And Your Honors, I apologize. When I said 496-501, that was a 2019 case. I got it confused with another SJC case from 2019, and that's 23656. So the case that I'm referring to is 23656, which I also cite in my memorandum, but I don't think I cite it for the reason that I'm arguing right now. But it's basically, again, it's you have to look at prejudice. And in this case, absent the application of factor 2, our argument is that substantial evidence continues to support the classification level.
How does, if we were to affirm here, could Mr. Doe apply for reclassification the day after the decision issues? And how should that affect our analysis of whether a remand is appropriate here?
Sure, Your Honor. It's been a little while since I looked at the appellant's record, but so long as he doesn't have any serious entries on his criminal record, and he's shown stability in the community, he would be able to apply for downward reclassification. And I think that's relevant to your consideration, because that's an important remedy that's available to all sex offenders. And the reason why the SORB affords that remedy is because we recognize that over time, one's risk to reoffend declines, so long as there's mitigating factors of the offender showing stability in the community, advanced age, things of that sort. So if he's eligible, that's a remedy that he should take advantage of, and then it's left to the hearing examiner to issue a new decision and determine whether a lower classification is warranted.
Well, I guess my question.
I don't understand. Should it make us? Should that weigh in favor of us affirming because he has this alternative relief, or does it weigh in favor of us reversing and remanding?
No, I would submit that it weighs in favor of affirming, because just recently, it's our argument that the level 3 is supported, but if he can show stability since the decision was issued in 2017, I think that would certainly weigh in his favor at a downward reclassification hearing in the future. But
if this decision is affirmed, does it impact a future hearing? Doesn't it impact that future hearing?
No. Well, I guess it's a de novo. The downward hearing would be a de novo hearing. So the hearing examiner, if this offender can show that he's had stability since his last classification in 2017, the hearing examiner would have to consider that evidence. And even if the hearing examiner were to find that a downward classification is not warranted and were to affirm the level 3, the offender would have an opportunity for judicial review. So that there are certain, due process rights in place that will ensure that the offender has a fair downward reclassification process.
And if he's had stability and was eligible to apply for reclassification, then the board would have to reprove its case by
That-
clear and convincing evidence, correct? In other words, the prior decision, assuming hypothetically that we had affirmed it, would not be given any particular weight. The board would have to prove all over again what level of dangerousness and risk of reoffense there is.
That's correct, Justice Sachs. And just to let you know, the prior decisions are admitted at the downward reclassification hearing, but again, it's a de novo hearing. The burden's upon the SORB. If the offender is indigent, he has a right to counsel. And if he's unsatisfied with the decision, he has a right to judicial review.
So am I understanding you correctly that anytime that one high risk factor is present, the classification will be level 3?
No, Your Honor. You just have to look at the totality of all the evidence and the regulatory factors that the hearing examiner applied. You know, in this case, there, as the examiner found, that there were no mitigating factors. So perhaps if there was mitigating factors, perhaps an argument could be made for a level 2. But compared to some of the cases that we cite in our brief, we believe that a level 3 is appropriate. For example, in 22188, the appeals court mentioned that there were several mitigating factors that warranted a level. Well, they didn't comment on whether there was substantial evidence for the level 3 classification in that case, but they did comment on that there was a number of mitigating factors such as advanced age, the offender participated in sex offender treatment, and he obtained a college degree through Boston University, through a program that Boston University has with the state prison. In this case, there's no mitigating factors.
So counsel for Doe argues that it's significant that the 15-year-old was not prepubescent. What do you say to that?
I still think that it's her age is relevant because under the regulatory factors, she is considered as a child. Under the law, she is considered as a child. So I think it's relevant that I believe the appellant was at the age of 28 when he had sex with the 15-year-old girl. So I believe that's relevant to his risk to reoffend. And even if one can make the argument that the appellant may not commit a contact offense in the future, my concern is also that he could easily go on to commit the crime of deriving support from a minor prostitute, because he has shown that he not only engaged in this illegal activity to make money, but in the past, he is shown to be a drug dealer to which he was indicted and convicted in federal district court, and his drug dealing continued in state prison, in which he was known in the prison to sell Suboxone. So my concern is that, you know, without any evidence that the appellant has a lawful job, he could easily go on to engage in illegal activity to make money, such as deriving support from a minor prostitute. And then finally, I know the good counsel below raised that the hearing counsel was ineffective for failure to introduce one particular scientific study. It was a 1998 sex offender recidivism study authored by Hansen, Dr. Hansen. But that study is cited in the board's regulatory factors. Additionally, the SORB's regulatory factors cite to another scientific study that updated we cite to a 2005 study by Hansen that updates the 1998 scientific study. And those studies talk about how antisocial orientation, which includes a history of rule violation, is relevant to one's risk to reoffend. And certainly in this case, the appellant has a history of rule violations with firearm offenses, assaults against, offenses against a person, and drug offenses. And so for all these reasons, once again, absent the application of Factor 2, the SORB submits that the appellant was not prejudiced by the application of Factor 2, and substantial evidence continues to support his classification as a level 3 sex offender.
Thank you very much. We understand your positions. The matter is under submission.
Your Honor, thank you and have a good summer.
The case is now being recorded.
Thank you. Members of the
Before,
panel,
I just need to, that's okay. I just need to call the case. We are now hearing our fifth case of the July 8th, 2021 sitting of the Massachusetts Appeals Court. It's case number 2020-P-1083, Richard Maglione versus Brooke Clenchy and another. And each side will have 15 minutes. There's no rebuttal in the appeals court. Attorney Keene, please proceed.
thank you. Members of the panel, may it please the court. As you know, I'm James Keene. I represent Mr. Maglione in a suit against the Neshoba Regional School District and Brooke Clenchy, sounding basically in discrimination, breach of contract, and estoppel. A brief recitation of the facts may be of help. Mr. Maglione first became employed by the district in 2007 and worked his way up to the custodial staff of the district over the years. In 2013, he obtained a position of custodial service manager for the district pursuant to a work agreement, which would close out usually on June 30th of each year. There were two renewals of this, taking us up to 2016. I should mention that the work agreement has a good cause term for discipline or termination, and that good cause is defined within the agreement itself. In May of 2016, his position as custodial manager was eliminated for financial reasons, and he was invited to apply for the position of head custodian of one of the schools, the Lancaster School, which he applied for, was granted, and was scheduled to begin work there on July 1, 2016. At that time, the district was in change of personnel with respect to superintendents, and Mr. Maglione was requested by the then acting superintendent if he could stay on through August to assist the new superintendent with the capital improvement projects that were then underway. He inquired whether that he could then go on to the Lancaster School as head custodian if at the close of that. He was assured that yes, he would.
So counsel, I have some questions that just make sure we understand what specific claims are at issue. So which contract are you arguing that the district breached? The one that ended August 31st, 2016?
Both the 2016 that ended there and the one that was breached to begin September 1, 2016.
Okay, so you're arguing both. All right.
Yes,
and do you claim error or abuse of discretion in the ruling allowing the defendant's motion to amend their complaint?
No, Your Honor. I've checked the law in Massachusetts, and it would be a fool's errand given the body of law on discretion afforded in such amendments, Your Honor. So no.
And are you Also, did you waive the individual contract claim against Brooke Clenchey?
No, it was ruled upon as in a motion for judgment on the pleadings. So she was out as to a party to the contract claim.
And is that included in your appeal?
No, Your Honor,
Okay. So that is out of the case?
that's out of the case.
Thank you. Can you point to a place in the record where you argued that the defendants failed to preserve the shredded documents?
With the defendant?
In other words, your complaint, my understanding is you're complaining that they did not preserve the shredded documents. They're saying you didn't, that you waived that issue. So I'm asking where in the record you preserved it.
I'll have to find that. It goes to the spoliation issue in both the destruction of those shredded items and to the videotape that was later, notwithstanding our letter asking that these matters be preserved. So with if you court's permission, I will send you a letter detailing where in the record that is. And I assure you it is.
So one other question, just so I'm really trying to shape what is at issue before us. As you know, there was some dispute as to what was shredded. Did your client provide some umbrella testimony along the lines of I only shredded duplicates or I only shredded documents that weren't important, or some saving comment like that, or will you tell me?
Yes, Your Honor. The plaintiff testified as to what was shredded, the old purchase requisitions, some old notes, and then that was basically confirmed by another person who said it looked just like old invoices for floor wax and all the miscellaneous stuff that comes in for a maintenance department. Important in that aspect on the import of those documents is that no investigation was undertaken. That Mr. Maglione told Ms. Clenchey and others that those documents were in two other repositories, one on the computer and two, the hard copies were in the treasurer's office and could be accessed.
Well, two questions about that. One, how can one prove a negative, prove that that nothing else was destroyed besides what already exists in two other places?
The best evidence for that is what happens afterwards, and nothing happened. It had no impact on the district. If I can use an analogy about getting your car fixed, the mechanic tells you, I did the work, I got it fixed.
Well, nothing, the explanation for nothing happening is perhaps that the evidence about what had happened previously that might have had some consequences had been destroyed, had been shredded.
Well, Mr. Maglione testified
it's not that they needed, in other words, it's not that they needed those other destroyed documents in order to continue with business as usual. It's a question of what wasn't known as a result of those documents being destroyed that might change things.
Well, Mr. Maglione testified as the content, number one. Number two, there was other testimony as to actually what was in that pile of things. And I have to reiterate that there's no consequences. I mean, that these documents were all held in other repositories.
Of course, if Mr. Maglione had made notes, you mentioned a moment ago that there were copies of past invoices and purchase orders and some notes. If he'd made notes, those wouldn't be preserved in the computer system or in a paper file elsewhere, would they?
No, they'd just be scribbling notes, for his day in, day out things that were on our desks, scribbled notes. But I have to reiterate impact on the district and two other repositories for finding those documents, and a request that the investigation to verify that they were available in other repositories.
I assume that this is all in support of an argument of pretext, that the proffered explanation that he was fired for shredding the documents, contrary to at least some understanding that there was concern about the documents, was pretextual. Now, is showing that a reason wasn't a good one equivalent to showing that it was not the real one, that it was pretextual?
In discrimination cases, the totality of the reasons given are examined. Bulwer versus Mount Auburn Hospital talks about the totality of the reasons given and not individual in isolation reasons to assess the determination on whether it was pretext or non-pretext. Hunter.
Okay, but if the main reason given here was he shredded the documents, you know, this Superintendent Clenchy might have been under a misimpression as to how important those documents were. But if that was her real reason, the fact that it wasn't a good reason or may not have been a good reason wouldn't make it pretextual, would it?
It could if you join it with others that are notably pretextual. She manufactured a number of other reasons for the termination, and I suggest that shredding alone is not enough. It had to get ratcheted up to insubordination in order to justify some termination. And that's what happened.
Why did it have to get ratcheted up to insubordination to justify a termination?
In my view, the shredding of the documents may very well be simply on a miscommunication between Ms. Clenchy and Mr. Maglione. And if it's simply a miscommunication, which happens every day in every setting, okay, it's really of no consequences. But insubordination, standing alone or in conjunction with others, may justify a termination.
So I suspect that Attorney Keston is going to argue, look, she said, don't take anything out. I want to talk to you about these documents, and that by shredding at them, he made that impossible.
Well, he didn't take anything out, and his position is that basically
he's not a teenager. That's an argument of a teenager, right? I didn't take anything out. I just shredded them into little tiny pieces so you can't look at them.
I understand that, but miscommunications occur. I mean, is every breach or every kind of breach of good manners in an employment situation cause for termination? I suggest no. If you ratchet it up, then you're going to get yes. But of particular import is looking at the various timelines here. And the court in the underlying case in the summary judgment proceedings resolved those issues against Mr. Maglione. And I believe that basically that's a jury question. I believe that the level of import associated with these documents was exaggerated in order to justify a termination, and a discriminatory termination, I should add. May I continue or?
Please.
Oh, I'm sorry. This is a de novo review of the summary judgment record as presented in the trial court. And I have to tell you that our star that guides us in this case and in this appeal is Bulwer versus Mount Auburn Hospital on what is required in a discrimination case and in the employment contract case. In this instance, Bulwer talks about the presentation of evidence and not the persuasion. The burden is not to persuade the fact finder, but that's left for the fact finder. As far as we have presented a presentation of evidence sufficient to prima facie case. And I want to go into the question of the court's finding of poor performance, getting over that. Now, the level of performance is in conflict. Number one is Mr. Maglione had very, very good reviews as far as his performance with it. Number two is Ms. Clenchy over the summer, praised his work in both emails and tried to get his position.
I think I understand your point from your brief about how the focus shouldn't be on whether the employee doing what he's alleged to have done meant that he performed poorly and therefore couldn't make out a prima facie case. That dispute really ought to occur at steps 2 or 3 of the McDonnell-Douglas analysis.
Yes, Your Honor.
That's your point?
Yes, Your Honor.
Okay. Maybe you can move to step 3 and tell us why this was a pretext,
Okay.
or what evidence that there was a pretext.
In the Lifshitz doctrine with respect to the proffer of numerous reasons for the employment decision, proof that any one of them is not true, okay, brings up the inference that it basically that they were discriminatory intent. In this instance, besides poor performance, we have non-cooperation. These are stated reasons for the employment action: non-cooperation, insubordination, conduct unbecoming, failure in duties, lying, dishonesty, actual or implied theft, overblown import of the papers. Continuing on, we believe that Ms. Clinchey authored or was a prime mover in the manufacture of additional false evidence by stating that one of her colleagues had also told Mr. Maglione about the import or the non-destruction or non-movement of the papers. And that simply is not true. That person testified never happened. The numerous reasons for termination, we say, are false. Granted that the manufactured evidence, the failure to investigate, the severity of the punishment, and without an investigation, the thing that sticks in my mind is her first reaction was to call the lawyers, not to call the employee and ask for an explanation. And to my mind, that's what was the motivation.
Didn't she have an explanation?
Did she have?
She already had an explanation. What
Pardon?
more was there to investigate?
Pardon? I'm sorry.
Didn't she already have an explanation?
Did she know? I think my time has expired, or
It is. Give you 30 seconds to wrap up.
okay. I think in a fair reading of our submissions in the underlying summary judgment, this case belongs to a jury. And I'm going to say that summary judgment is probably the most draconian measure in civil practice, and it denies a person a right to have his claim before a jury. And I can tell you, as an experienced, long-term experienced lawyer, that's tough to explain to a client why they can't explain the situation to a jury. And I'm asking you to reverse and send this back for a trial. Thank you.
Thank you. Attorney Keston, we'll hear from you now, please.
Good morning, justices. It is always an honor for those of us that primarily live in the Superior Court and the U.S. District Court to appear before the Appellate Court. This case reduces itself to one action. Mr. Keene talks about various reasons. There's only one reason that Mr. Maglione was terminated. And that reason is uncontroverted. There's no suggestion it's a false reason, or there was any other motive. All you have to do is you look at the email that she sent him before he left, when he was on vacation, in which she said, when you return, we need to touch base on your transition time and the piles that were in your office. Although they are safely stored in the conference room for now, they're a concern, and we need to have some discussion regarding them. That is not ambiguous. Safely stored. Well, they were safely stored until he went in there on a Sunday and destroyed them. And yes, I like Justice Henry's likening to that argument that he didn't take them, he simply shredded them. As a teenage, I suppose, however you want to call it, we certainly got a good laugh out of it, but I didn't do anything to it. It's still there. I suppose the suggestion is we hire those young people from Argo, and if you saw the movie where they reconstructed shredded documents from the US Embassy in Iran, we could have hired them and done that. So the question is really Ms. Clenchey's state of mind here, what she thought. Yes, Mr. Maglione testified that it was mostly duplicates, but he said he couldn't be sure exactly what he did. But let's assume it's true even. How was she to know? And this two repositories argument is frankly silly. Yeah, there's repositories of documents that he's going to tell her that he shredded, but there's no way to know. And why did he shred them? Why would he go into the conference room and shred them? He came in that day, he says, to clean out his office, take personal stuff. These were not in his office. These were safely stored in the conference room so she could talk to him about them.
If the superintendent says, not only I told you not to do anything with those documents, but I had a colleague of mine tell you the same thing, and that were shown indisputably to be false, would that amount to pretext?
No. Because you have the email. First, we don't have those facts that it's indisputably false.
Yeah, I'm just asking a hypothetical, just.
I hear you. I mean, if it was proved that she was lying, if it's well, it's never indisputed, right? We have.
All right, but we're talking about whether there was a
I hear
jury
you.
question as to pretext here.
Is there a jury question because it's not in dispute if somebody says, I didn't tell him that? I say absolutely not because of the email. I mean, and his testimony, if you review his testimony, he knew that those documents were important and she wanted to talk to him about it. He's never denied
Okay.
it. So he knows that and he destroys them anyway.
But does the fact that, or the assumed fact or evidence that the district tried to bolster and build up and strengthen the reasons for its termination itself suggests pretext?
I say no, in light of these facts, where there's actual uncontroverted evidence that she told them that. Because what we're trying to prove, right, what the district wants to prove is that he knew that he shouldn't be destroying those documents. So it's uncontroverted that she told him not to. They were safely stored and she wanted to talk to him about it, that he knew from her. If it's proven that, her memory that somebody else told him turns out not to be true, I don't see how that changes that fact at all. It has to be.
I guess the question is, if the employer feels it necessary to manufacture evidence, and I'm obviously putting it in the worst light for your client, not necessarily what the record says. If the employer feels it necessary to manufacture evidence to make the case for termination appear stronger, then does that give rise to an inference that actually there's something else going on?
It can on a different set of facts. Again, because the issue is uncontroverted that we're talking about. If it was disputed, if she said that I told you and John Doe told you and Justice Henry told you, and he
so
said,
it's the
"None of you
reason
told me,"
for termination that's given, not the facts regarding how many times and in what ways that reason was communicated, or the basis for that reason was communicated.
Yeah, the basis, the material issue is, did he know? Was he told that these documents were important? Uncontroverted that he was. So it's not that there's nothing to bolster. You have an email. I mean, you can't get more uncontroverted than that. And he doesn't deny it. And that's why he came up with his, when he talked to me, he came up with his, I didn't take them. They're still there. Explanation. Because he knew that he shouldn't be doing it. So I hear you, Justice Sachs, I agree with you. If this was a material question, and if there was some evidence that they were lying about, that they bolstered it and lying, now you've got an inference that maybe they're making it up, but it's not on these facts. Not on these facts. It can be on different facts.
I mean, in this case, he's got these two different claims. He's got the discrimination claim and he's got the contract claim. And if they're bolstering because they don't think they've met this good cause standard, is that an objective standard? Or is that a subjective standard? I mean, is that up for the jury then to determine whether him shredding was good cause?
Well, oftentimes it's a jury question, but not when the facts are uncontroverted. Not only facts are uncontroverted, that becomes a question of law. We can't have a situation where a jury says, you have this same set of facts and one jury says not good cause, one jury says is good cause. The facts are uncontroverted. He got the email, forget everything else. He got the email. He testified that he knew, she told him. And he testified that despite the fact that she told him he didn't take the stuff, he thought he didn't take the stuff, he simply shredded it. He didn't take it. He absolutely took it This is, I didn't take, if he had taken these stuff to Lancaster, we'd be better off. We'd still have it. We could look at it. He actually destroyed it. And how any employer would not think this is a problem. When you look in the record, she told him, what am I going to tell the school committee? How am I going to explain what you just did? The paperwork's a problem. I wanted you to talk about it. And you came in on a Sunday and destroyed it. And your explanation is I didn't take it.
Right, but what's the basis for saying the paperwork is a problem? Right. In other words, let's just assume his office was a complete mess with stacks and stacks of paperwork. And she's horrified because she's a really neat person and she says this is a problem. Why do we have to take that as a given if we're looking at this in the light most favorable to the plaintiff? And he's saying everything in there was duplicates.
Well,
there's no credibility. We believe him. Don't we believe him?
Well, at this stage, I was just discussing this the other day about this question, because you have to, at this stage, take everything in the best light to the plaintiff. So let's believe him. Let's say today, for the purpose of this argument, we believe him, that that's all he did. But you have to look at her state of mind. She didn't have to believe him. We're not at that stage. What is her state of mind? Sure, he says, they always say I didn't destroy anything incriminating. Nobody comes to you and says I destroyed the evidence that I stole a printer, which happened in one of my cases. They don't tell you that. You have to find it out. But so even if we say, okay, he didn't destroy anything incriminating, which of course he says. What is she supposed to think as a supervisor? Because the email is really telling. I urge you to focus on the email because it's really an uncontroverted, objective.
Well, so he says that she agrees that he did not have malicious intent when he shredded the documents. Does she agree to that?
That she agrees that he didn't? I agree that she said that. I don't agree that she thought that. But she said it. That's in the documents. That for the purposes of this, you have to assume she said it.
Okay.
It wasn't malicious, but she also said, how am I going to explain to the school committee? I've talked to counsel. This is a real problem. She said a lot of things about this situation and how could you do this? And this is why I'm doing it. So if we assume all these things are true, she's absolutely acting in good faith. And there's no suggestion of age. The age discrimination simply comes out, you search for the protected classes and we got one here. There's zero associated evidence of anything like that this was because of his age. Had he not shredded these documents, he'd be happily working in Lancaster now. She gave him another job. Everything was set. Everything was going to be fine, except he came in on Sunday. And, I look at this, I kept looking at this email for a long time, from the beginning, safely stored.
What was the worry about the documents? Because that's what I don't understand.
Well, now we're getting into that there was some irregularities. You always that. Why else would you be worried about preserving documents? I need to talk to you. There's no suggestion of neatness, Justice Henry. This wasn't, I'm concerned about your desk, which happens in my office every day. And when I go on vacation, they clean it and I come back and it's messy. So it wasn't that. She's saying the documents are safely stored in the conference room and I have concerns. I'm going to talk to you about them. And he comes in and shreds them. What would your inference be? He comes in on Sunday and they're gone. After you tell him they're safely stored, she said. There's no ambiguity in this email as to what's going on here, that he somehow thinks it's okay for him to just destroy them. So it raises the suspicion. Why are you destroying them? You may think somebody's doing a great job as your clerk, and all of a sudden, if they all of a sudden start shredding things that you're trying to look at, don't you wonder what's going on? And here we have purchases. So of course it raises a specter for everyone. What did he do? What was in it?
May I ask you a question about the contract claims?
Yes, sir.
We know what the cause standard was under his contract as the interim custodial services manager for the last 2 months. But put that aside, assume hypothetically that that whatever contract governs his expected employment as head custodian for the Lancaster schools was in effect. at the time he was terminated. I understand that he wasn't scheduled to start until September 1st. He was terminated on August 31st. But let's assume that that contract regarding Lancaster Public Schools is in effect. What is the applicable cause standard, given that he's not a union, it's a collective bargaining unit, but he's not a bargaining unit member for 90 days? What if we reached that issue, how would we determine whether there was cause?
I don't think they need cause. I think it's probationary for 90 days.
So he says he's not, though, because he was just transferring from another district position. How do we figure that out?
Well, I don't think you have to, because I don't think there's any way, there's any, what we call, we just did in a meeting, a straight face argument that on August 30th, the September 1st contract was in effect. You know, if it wasn't in effect. He hadn't started. This was still under, you know, under the old contract.
Do we even have a copy of that collective bargaining agreement in the record?
The short answer is I don't know. I didn't write the brief. I edited it.
But that is the contract, if any, that would be applicable to his employment starting on September 1st.
Yes, sir. Absolutely. If that is true. So I will look. I will certainly let you know shortly when I talk to somebody who knows. But we just never focused. We've been focused on the age discrimination claim because we think that's really the only viable one. And actually, we had a lot of interesting. And my son is taking the bar this month. I said, this question as to what applies, what happens after the workday of the last day of your contract, if you still have a contract, is a law school question. It's a bar exam question. Yeah. What happens? We looked at it.
I do see the collective bargaining agreement in Record Appendix 1 at page 278. It's the contract between Neshoba Regional School District Committee and Neshoba Regional Education Association Unit C. Is that the one that would apply?
I'm assuming. Again, I don't want to make things up. I can find out. My first appearance at the SJC, I was asked a question with Justice Marshall, and I said to her, I actually have no idea, as opposed to trying to make up. So I don't know. We will take a look at that. But this is, to me, that I have always thought, I believe the focus of this case has always been this discrimination claim. But if you just, my time is running up. If you just simply look at the uncontroverted facts of what happened at the end of August of 2016, I don't think there's any question that there is no lawsuit here. It's unfortunate. It's unfortunate that he did this. Unfortunately, he lost his job. But there is no lawsuit.
We'll have to leave it there. We understand both of your positions, well argued, and the case is submitted. Thank you.
Thank you.
So what, we're going live.
I will call the case, by the way, before you start talking.
The case is now being recorded.
Thank you. This is our final case for this panel for today, July 8, 2021. The case is case number 2020-P-1205, KR versus AR. Attorney Dargy.
Yes, Your Honor. Your Honor, may it please the court, my name is Ann Dargy. I'm appearing on behalf of the appellant defendant, who is referenced throughout the briefs as the husband. The appellee is referenced as the wife. Understanding that the court has reviewed the submissions, I will turn to the very narrow issue addressed in this appeal, is whether the evidence presented by the plaintiff wife is sufficient to warrant the issuance of a 209A abuse prevention order in the district court.
Can I just get clear as to
Yes.
the scope of what you're challenging? Originally, the order had some provisions regarding the children. Those provisions were vacated. Isn't that whole issue moot? So we just need to focus on the order regarding the stay away and no contact with the wife.
I think that the issue with respect to the children, though, Your Honor, is that it was still part of the record, and my client is looking for the entire record to be expunged. And so whether the issue of the children needs to also be found by this court, I believe is relevant to having the order vacated in its entirety.
But if we upheld the order as to the wife, then we wouldn't have to go on and resolve any issue as to the order regarding the children. Is that accurate?
My instinct, Your Honor, is no, that the subsequent modification that was entered by the probate and family court was a different judge. My understanding is that this court is charged with vacating the order. Well, I think Peter said that the order relative to the children was entered as part of the order that was entered relative to the mother. Because in this case, this is not an OBO case. There isn't any specific allegations of abuse relative to the children themselves. So if Your Honor is vacating, or if Your Honors choose to vacate the order relative to the wife, then of course the order would vacate regarding the children. I don't believe that the subsequent modifications necessarily can impact that initial order that was made.
Just to put a fine point on it, there is no order in place as to the children right now. Is that right?
That is correct, Your Honor. The probate and family court did vacate the order relative to the children, so the parties have been operating under their separation agreement that was filed in the probate and family court under that regular parenting schedule, yes.
But just to be clear, or to make sure I understand, even if everyone else already does, if we affirmed the order as to the husband, hypothetically, what is there that could be expunged as to the order's provisions regarding the children? I mean, what goes in the central registry is the issuance of an order.
Right.
And if the order was found to be unjustified from the get-go, then it gets vacated. But if part of the order is held, and I'm speaking generally here, not to have been unjustified, then can those parts that were unjustified be this order subject of a separate targeted expungement order?
Well,
Is there any case saying so, I guess?
Well, I think this is a somewhat tricky part between the continuing jurisdiction between the probate and family court and the district court as it relates to 298 orders, because the probate and family court was able to remove those provisions, the paragraph 6 and 7, following a separate hearing. There was another hearing, time had passed, there was an oral argument by counsel at that time, other motions filed, there was a modification filed, and it was vacated under those provisions. So my concern in saying that that issue is now moot when it was not done by the original issuing court, I think is concerning. And I don't.
Well, why would that make a difference? If one judge issues an order, pick any civil case that you want, 209A or otherwise. One judge issues an order at a preliminary stage of the case. Then later on, another judge vacates that order. And then at the end of the case, there's an appeal. Why would we have to go back and look at whether the first judge properly entered the order if the second judge had vacated it?
My understanding, Your Honor, was for the purposes of the expungement, that if Your Honor was going to, if the entire order was going to be expunged, Your Honors would have to find that it was improperly issued across the board on each of the points in it was initially entered. I certainly am happy to rest on my brief as it relates to children and discuss the specifics relative to the wife. I do think that they, in this particular case, are certainly related. The court made those specific findings relative to the husband's mental health and stability. And for those reasons, and as we assert in the brief was speculative, entered the order with respect to the children, but we believe also entered that order with respect to the wife. That there was, the timeline in this case is very important. The parties were engaged in divorce mediation. There had not been a contested divorce yet filed. They were working with a mediator throughout the months of April and June, as testified by the wife. Did not have counsel for their divorce, but they were mediating. They were working together. They continued to live together and worked toward developing the provisions that were ultimately memorialized in the separation agreement on June 19th of 2020. Where that becomes important is it really differentiates some of the cases cited in the opposition brief that relate to, in part, the children, but other cases that talk about the reasonableness of the fear. The wife notes a number of incidents, particularly those that went on in April and May 30. There was an April 26th incident, a May 31st incident, that the wife alleges those caused her fear, but continued to, up until June 2nd, reside with the husband. Even following her leaving the home and residing with her parents, the parties continued to work together. And then on June 19th, entered into an agreement to share legal and physical custody of the children. And that point is particularly important and somewhat nuanced. Sharing legal custody does require the parties to communicate and requires them to make shared decisions relative to the children. It requires them to, and then the shared custodial arrangement with respect to the schedule, in this particular case, it was a week on, week off schedule, also requires the parents to be in regular communication and requires them to, I would argue, trust, particularly from the wife's perspective, trust that the husband cares for the children, that is stable enough to care for the children for a long stretch of time, and is stable enough to co-parent with her. And so
counsel, why, first of all, people can be in denial for a very big significant factors, but why can't the two incidents happen and then the subsequent text messages from the husband color one's perspective about the two incidents of shutting her arm in the car door and throwing the beer bottle at the television?
I color in terms of I'm not sure I understand your question.
Make you start to see those incidents in a different light and worry that there's escalation.
In part, Your Honor, because even with the text messages that occurred around the same time as those alleged incidents and after, notwithstanding, the wife continued to in good faith, entered into that agreement that there was going to be this sharing of parenting responsibilities. And I think that the other important response to that question is that the wife's reaction to those incidents and to the husband's text messages certainly indicate from her testimony and from her response that she wasn't afraid. There was a time where she said, I believe this was after the beer bottle incident, where she responded something along the lines of an LOL regarding the slashed tires, or it was a laugh out loud text message regarding the slashed tires. She apologized for her own role in that incident and some issues around the weekend. She continued to communicate with him. And so I think that if the text messages if any of these incidents are looked at in a vacuum, certainly there could be some concern. But looking at this case on a whole, it's clear that the parties were in conflict, but it's also clear that the parties worked very hard together to keep the children apart and away from the conflict, which demonstrates a level of stability and ability to co-parent. And I think that there's also, a pretty clear, unfortunate situation of what is sometimes termed as, although we don't try to term it this way in probate and family court, a custody battle. The parties were engaged in a very difficult split. That there were emotions on both sides. There are text messages in the record where the wife is also apologizing for her own dramatic behavior, and that it was a challenging time. I think that to the point made earlier, ultimately this issue around the children was vacated, the probate and family court. And so there is a thought that when looked at on with all factors taken into consideration, the wife didn't meet her burden of demonstrating that she had reasonable fear, which she is required to do. And
was there testimony that the husband broke the lock of the bedroom door of the daughter while the wife was inside the bedroom?
The wife makes that claim. That my understanding from her testimony was that he pushed the door open, and that something on the door broke, whether it was the lock or the handle itself. I don't know if she specified, but yes, he did push the door open. And after that, the parties went together downstairs, cleaned up this, beer bottle, broken television incident, had a subsequent conversation. My client left the home. I believe he said he took his pillow and slept in his car. The parties were able to separate. Again, there was the text messages from wife, apologizing for what I believe it appears that she recognized that she started sounding juvenile, started this fight and brought up some issues that were sensitive at that time, which she apologizes for in text message. He left the home. There wasn't any, I certainly think it's a demonstration of the conflict that occurs in these kinds of relationships as these relationships break down. But again, looking at the whole, the client was not out of control. He left the home. The parties were able to separate themselves. I believe the wife said that she slept in the daughter's bedroom. They went about their day. There was no police involvement. There was no hospital involvement. There was none of some of those hallmark pieces that we see when there's an increase or a ramping up unexpectedly of a domestic violence scenario. In this particular case, the only time the police were ever called to these parties to manage these parties was when the wife herself broke into the home. And again, I think the wife took some fairly active steps from her perspective to involve herself with the husband. There was testimony and text messages that she would invite him over to go swimming. There was certainly a significant amount of testimony around her breaking into the home, knowing, and I believe she testified, she knew the husband didn't want her there. She broke into the home through a window, taking things. I think that any person who is that aggressive about getting close to another person, it's very hard, I think, a very hard stretch to say that she's afraid of him when she knows he's in the house and breaks in through a window and demands her things.
Why is that not just a matter of a credibility determination for the judge who heard this?
I think that the judge looked at some of this in a vacuum. I think the judge saw these individual pieces and some of the admittedly unfortunate language that my client used, and really took a position that there was a mental instability that wasn't there. I think that it was truly, it was an abuse of discretion not to consider these other factors and this other behavior by the wife, other incidents that had gone on between the parties, and to recognize that my client's statements, while somewhat unfortunate, certainly didn't rise to the level of an abuse prevention order, but really did, were mitigated, if you will, by the wife's behavior and her own reaction to what those text messages and his behavior was. So again, as I said, my client does not believe their wife has presented evidence sufficient to issue the 209A abuse prevention order. We specifically cite the case in Woolridge v. Hickey, and in Smith v. Jones, where this court has said that the 209A effectively not to be used to govern relationships that break down and that are conflictual at times, and not be used for that purpose. So he is requesting.
Yeah, I just wanted to ask one final question. The judge finds on the record at the end of the hearing, I find by a preponderance of the evidence that there's been a pattern of abuse by the defendant against the plaintiff for a reasonable fear of imminent bodily injury. And by that, I mean to wit, death. I take the threat from July 28th that he would like to go back in time and portray his marriage as a very happy one and then kill her as a threat. So if that alone is true, that would support if that finding alone stands, then that's enough to issue this order, isn't it? We would have to affirm.
I think the problem with that, Your Honor, no, I think is my answer, because that was not a direct threat. It was made on the phone. There was cross-examination.
But unless we find that, maybe I wasn't clear, unless we find that clearly erroneous, we've got to affirm.
Yeah, I struggle to agree only because I don't believe that threat in the way that it was made and the facts that were presented around it, I don't believe rises to the level of a 209A abuse prevention order.
Thank you. Yeah, you answered my question.
Okay. Thank you, Your Honors. My time being expired, I'll rest on my brief.
Thank you, counsel. Attorney Sandberg.
Yes, Mary Sandberg for the appellee wife in this case. This case there was evidence sufficient to support the finding that the wife was entitled to an order of protection from abuse. The statutory requirement of 209A Section 1B is showing that her fear of imminent harm was met through all of the evidence submitted. And it is very important in this case that it's not one incident that occurred, but it was a series of incidents that caused the wife to fear for her safety. It was a totality of the circumstances case. And I would agree with appellant's counsel that the timeline in this case is extremely important. And I think Justice Henry was accurate in her suggestion that perhaps an incident that may not have been so concerning over time with the accumulation of incidents that increased in number and in hostility would cause the wife to be concerned for her safety and for the safety of the children. So the timeline that I would like to point out that's very important in this case, that it was a series of incidents that caused her to be fearful. We've set out the truck incident in our brief that occurred on April 26, 20. True, the police weren't called in that incident. The wife tried to retrieve her cell phone that the husband had taken from her, put her hand into his truck. He slammed the door on her hand. She submitted photographs of the injury of her wrist. By the end of May 31st, there was the TV incident. The husband threw a beer bottle at the television, broke the screen. The wife left and went up to one of the children's bedrooms and locked the door. She did testify, and it's in her affidavit in support of the request for the restraining order, that the husband broke the lock and demanded that she come downstairs to help clean up the mess that he had created by throwing the beer bottle. She left the house with the children the next day. By July, there were a series of text messages to the wife from the husband that were increasingly hostile. By July 10th, he was saying his anger was overwhelming. By July 15th, he was telling her that he had hoped that she would be killed in a car accident. So then the insurance money would help him support the children and he'd have the children back. Then by July 21st, he said, well, if I drive by and see someone else's car there and you're there with the children, I'm going to lose it, causing her immense fear. So that by July 28th, when there was the telephone call between the parties, and the husband said, I would like to go back in time and I would have killed you. That's the comment that the judge found would be the trial judge found that would constitute a threat to kill her. And that was at Record Appendix 1 on page 147. And I believe Justice Sachs has already referred to that. It certainly would warrant that alone.
Could text messages in the telephone call of July just on their own constitute a sufficient basis for issuing that order?
Your Honor, I believe based on the cases, for example, Ginsburg and Noel that I cited in my brief, it's the accumulation of all of the text messages and the telephone threat and the breaking of the TV and the incident with the car. It's a totality of the circumstances. It's the number of incidents that occurred. It's not just one incident. I don't know that one incident would have caused her to have sufficient to obtain the restraining order, but I think all of the incidents and perhaps even the threat that the two that he wished he could go back in time and kill her, or the threat that he would hope that she would be killed in a car accident. Those two alone might have been, and the trial judge certainly did find that that was a threat, and she questioned him on those issues and said, what do you mean by losing it? What would you do? And she didn't find his explanations of his comments and the relentless text messages that she found to be having extreme hostility. She didn't find his comments or his excuses to be credible. And that goes to the credibility here. The judge was the one who heard the party's testimony and heard about all of these incidents and determined, yes, this woman does need an abuse protection order to protect her and at that time protect the children. I mean, after the telephone call, there were two more text messages that were very concerning. I get, by the 29th, the day after the phone call, I get more and more angry every day. By the 29th, he said, you know, I'm going to snap someday and you'll wonder what caused me to lose it. I mean, you know, her fear, this is what caused her to go into the court. She prepared an affidavit for the court to ask for the preliminary restraining order. And in the affidavit, she set out all of the incidents that caused her to be increasingly fearful for her safety. She described those incidents, and as of August 4th, she had gone in to obtain the temporary restraining order. Then the hearing was in August 13th, and there was sufficient evidence presented at trial, not only her testimony, where she talked about her increasing fear about the numerous messages that he had sent. The husband had an opportunity to rebut the text messages or to explain, and the judge didn't find that his excuses were credible. I mean, the record speaks for itself on the escalating extreme hostility that was evident, and the judge was certainly warranted in finding that this you know, that the husband's, you know, erratic behavior, and whether she caused it mental instability or instability, I mean, it was perfectly obvious by all of the evidence that was admitted that the wife's fear was reasonable, and it was the trial judge's job to determine whether her fear was credible. And the husband couldn't dispute that he hadn't sent these text messages. And I think if you look at our record appendix, Your Honors, you'll see that they're not only hostile, but they're degrading, they're derogatory, they're increasingly threatening. And she was left with nothing but the necessity of going in to obtain some abuse. And she even says at the end of her affidavit in support of the restraining order, look, he's hostile, he wants me dead, he has guns in the house, please help me. And she was helped by the issuance of this restraining order. So, Your Honors, I would ask you to take a look at all of the evidence that she submitted and affirm the order of protection from abuse. I don't know if you have any further questions on this case.
Any other questions?
I have one question, which is about the provisions regarding the children. Is that issue moot in your view?
Well, I don't believe so. I'm kind of struggling looking back, and it's not a case that either one of us has cited, but I think the Frazato case dealt with this issue, and I believe that the issue is not moot when it comes to unfortunately, I think when it comes to the defendant's right to have the order expunged.
Okay, but I guess I mean, we can go look at the Frazato case, but does that stand for the proposition that if part of an order was found later to have been issued erroneously, that part can be expunged even if some other part of the order remains in effect? Or is expungement an all or nothing thing with respect to the order as a whole, not particular paragraphs?
Your Honor, I do not know. I don't know what the case law on this is. That's a question that perhaps will have to be resolved by this court. I mean, I would argue on behalf of the appellee wife that there was ample evidence, including the children in the restraining order, that we don't need specific incidences regarding abuse of the children. But again, we look at the totality of the circumstances, and that many of the text messages were concerning the children, and they were present for a couple of the incidents, even though they might have been, asleep up in the bedroom. We don't know, what they could have heard. So my position for my client would be that the judge was certainly did not err in including the children in this order, and that they needed protection at that time. Both the wife and the children. But as to answer your question, Justice Sachs, I don't know the answer, whether we can piecemeal part of it out or keep part of it in.
Did the wife appeal the order vacating the provisions related to the children?
She did not.
Thank you. Any other questions? Seeing none, I think we understand everyone's position. And well done. And the case is under submission. That concludes today's sitting of this panel of the court. I just want to thank all of our staff, including our clerk, for all your hard work to keep us going and keep the technology moving so that we can continue